Last Thursday, a federal court barred a Washington spa from excluding trans women for religious reasons. Welcome back to In Case You Missed It, a series where I review recent court decisions around the country you may not have heard about. Today's case is Olympus Spa versus Armstrong, decided by the Ninth Circuit Court of Appeals. It began in Washington state when two Korean-owned spas were sued by Washington's Human Rights Commission for violating Washington's anti-discrimination laws. For entry, the spa required patrons to have specific biological characteristics which excluded trans women. The spa owners claimed that the policy was an expression of free speech and an exercise of their religious beliefs, both protected by the First Amendment. Nevertheless, the trial court found that the language of the spa's entry requirements were especially discriminatory and therefore violated Washington state laws. Olympus Spa then appealed to the Ninth Circuit Court, which affirmed the decision. When addressing the free speech claim, the court applied what is known as intermediate scrutiny. It is a tool used by courts to judge the constitutionality of a law. To pass an intermediate scrutiny test, a law must further an important government interest and must do so by means that are substantially related to that interest. The opinion, in this case, held that the law prohibiting discriminatory speech was an essential burden on free speech to further the government interest in eliminating discrimination. Therefore, there is no violation of free speech because the Washington law passed the intermediate scrutiny test. Next, the court applied what is known as rational basis review when addressing the claims against practicing religion. The rational basis test is similar but less strict than the intermediate scrutiny test because it does not necessarily take into account the burdens on other interests. Overall, the court used this test to conclude that eliminating discrimination on the basis of sex is a legitimate government interest, and public accommodation laws like Washington's are rationally related to the elimination of discrimination. This establishes an important precedent that the government does have a compelling interest in protecting all individuals from sex discrimination. Thank you for watching, and I hope you enjoyed.